Hello, I'm Cornell Clayton. I'm the director of the Thomas S. Foley Institute at Washington State University. And on behalf of the Institute, I want to welcome you out to our program today. This will be the last program we have this semester, but we'll have a full slate of programs next semester that you can join us for. Today, our program is going to look at intellectual property rights in Indian country and the appropriation of Native American artifacts and imagery. This is a very important topic. It was suggested to us by a group of Native American students here on our campus. And it's really a pleasure for us to work with our student groups to bring you these types of programs. I want to thank the co-sponsor of today's event, the Office of Native American Programs at WSU. I also want to thank especially Michelle Lee, who's a student intern in the WSU Pre-Law Resource Center, who was really responsible for organizing today's event. It's important for us to recognize that Washington State University is located on the homelands of Native peoples who have lived in this region from time immemorial. Currently, there are 42 tribes that share traditional homelands in what is now the state of Washington. It is my pleasure to now introduce to you the two students who will moderate today's discussion, and they, in turn, will introduce our speakers. Vincent Gonzalez is from Yakima, Washington, and he is a member of the Puyallup tribe. He's a senior majoring in psychology with a minor in sociology. Vincent is a mentor for multicultural student services, and he is the treasurer for the Native American Women's Association. Our other co-host today will be Jamie Ness. She's a sophomore and a member of the Navajo Nation. She's a double major in science communication and multimedia journalism. She does public relations for the Native American Women's Association, and she is a member of the multicultural Greek chapter of Alpha Pi Omega. So Vincent, I'm going to turn the time over to you and your co-host Jamie, and I'll let you take it away. Thank you very much.
Thank you so much, Dr. Clayton. So to continue off, we would like to start off with a land acknowledgement. You already touched on a little bit of that. But Washington State University acknowledges that its locations statewide are in the homelands of Native people who have lived in this region from time immemorial. Currently, there are 42 tribes that share traditional homelands and waterways that is now Washington State. The university expresses its deepest respect for and gratitude towards these original and current caretakers of the region. As an academic community, we acknowledge our responsibility to establish and maintain relationships with these tribes and Native people in support of tribal sovereignty and the inclusion of their voices in teaching, research, and programming. I would also like to remind people that we do have a Q&A at the end of this session, and if the audience has any questions, please put them in the chat or email them to tsfoley@wsu.edu.
All right, hello everybody. We have the pleasure to have Professor Trevor Reed. He's an associate professor in the Sandra Day O'Connor College of Law at Arizona State University. His research explores the social impacts of intellectual property law on individual and group autonomy. His recent publications include Who Owns Our Ancestors' Voices? Reclaiming Ownership of the Indigenous Voice in the Oxford Handbook of Musical Recreation, and Listening to Our Modern Lives in Music and Modernity. We also have the pleasure to have Ms. Cora, proud member of the Navajo Nation. She graduated from the Indian Legal Program at the Sandra Day O'Connor College of Law and has worked for the Salt River Pima Maricopa Indian Community and the Recon Band of Louis Sueno Indians in their Office of General Counsel and Attorney General.
Okay, well, thank you very much for that wonderful introduction. And I want to thank, first of all, Michelle Lee for extending the invitation for us to speak. And I want to thank Richard Elgar and the Foley Institute for Public Policy and Public Service for inviting us here. Thanks, Professor Clayton, for the kind introduction, and also Vincent and Jamie for moderating the event. I likewise want to acknowledge the 42 tribes located in present-day Washington State, their ancestors. And I want to also acknowledge the indigenous peoples on the homelands where I'm at currently, the Akima Oldham and the Peepash peoples here in Arizona. I come from the Hopi tribe, Nut Pahu Waitiwa Yan Matsua. My name is Trevor Reed, And I'm excited to be here along with my co-presenter, Cora. I'll go ahead and let her introduce herself, and we'll get moving on our program for today.
Good afternoon, my name is Cora, and I recently graduated from the Sandra Day O'Connor College of Law, Indian Legal Program back in May 2020, and I'm currently studying for the Arizona bar exam and getting ready to enter the Indian law field as one of the first, or the first attorney in my family. Thank you for having us.
So I think just to get started here, we're going to talk a little bit about how intellectual property works in Indian country. There are lots of different ways that we can approach this topic, and it's expansive, and there's so much work that needs to be done in this area. But we want to just focus on a couple of specific areas. In a second, I'll ask Cora to go ahead and give an overview of the different areas of intellectual property so that you have those kind of in your mind. But just to give you a rundown of what we're hoping to accomplish today, we'll be talking first about the appropriation of Native American voices over the last century and a half that we've had recording technologies available. We'll also touch on Native American fashions, the way that the fashion world has appropriated culture from Indigenous peoples. Then finally, we'll get into a little bit of the complexities when we talk about IP and social media today, how the different things that we need to look out for as we're using social media, and also as we're kind of policing social media in our day and age. Finally, we'll touch on a little bit how we can all get involved, the way that we can use IP, and also the way we can help tribes protect and promote their creativity and innovation. So I'm going to turn the time over to Cora to give us a little bit of an overview of the different areas of intellectual property law.
Thank you. So intellectual property law deals with the rules for securing and enforcing legal rights to inventions, designs, and artistic works. Just as the law protects ownership of personal property and real estate, so too does it protect the exclusive control of intangible objects. And so you'll see on the screen that some of the areas of intellectual property law are patent law, trademark law, copyright, trade secret, and right to privacy. Though in this presentation, we'll only be going over trademark and copyright laws and examples of those infringements in Indian country. We would love to take any questions about patent law or trade secret or right to privacy during our Q&A. Patent law covers and protects inventions and functional designs of things. Trademarks protects things like brands and logos. And you'll see a variety of examples that we've curated for you all in the next couple of slides. Right now, Trevor will take it away with our first example of copyright and Indigenous music.
All right. So one of the things that I've been working on for the last several years is trying to help tribes be able to protect the materials that were recorded or otherwise expropriated from reservation lands back in the boom of anthropology, when people were coming out to reservations and capturing all kinds of data from Indigenous peoples. So I specifically want to talk to you about how copyright might help tribes that are trying to reclaim that material from institutions that are still holding it today. I'm going to start by telling the story of this woman. Her name is Laura Bolton. She traveled to my homeland, the Hopi Reservation, in 1940, accompanied by a couple of Bureau of Indian Affairs agents. And there she recorded about 120 songs, many of which would probably not be allowed to be recorded today on our tribal lands. Bolton was a collector of Indigenous music. As you can see kind of in the bottom left-hand corner, she styled herself the music hunter. So that kind of gives you an idea for the kind of ambition she had. But basically, she was a trained vocalist and a graduate student in anthropology, and she decided that she would use her social networks and the new recording technologies that she had available to her to travel to various Indigenous communities and record materials. Prior to arriving on my homelands of the Hopi tribe, she actually signed a record deal with Victor Records, which later became one of the big 5 record labels. And she agreed that she would produce an album of Native American songs. This was before she had even set foot on a reservation. So she went ahead and did that. She traveled out to the Southwest and she started recording. Now, Bolton, there we go. In 1941, the year after she traveled to the reservation, she came back to New York and created an album of indigenous music. It ended up selling 5,000 copies or so through 1986. We actually don't have the statistics for post 1986, but it's actually still available for sale on iTunes, on Amazon, you can even stream it on Spotify these days. But she ended up signing these record deals, and then she transferred all of her remaining recording rights. She had recorded over her lifetime about 30,000 tracks of indigenous music. She transferred all of those to Columbia University in a deal with the university to give her a named professorship and an annuity for the rest of her life. What's interesting about Bolton is that she was a meticulous record keeper, right? She kept everything, calendars, all of her correspondence, but amazingly, there are no indication that she ever signed any contracts with the people she recorded. No royalties were ever sent to the performers or the families, and at least there's no evidence of that in her voluminous archive. There's no discussion of any agreements that she ever made with her informants about who could reproduce these recordings, who could distribute them, who could publish them. So now some of our sacred ceremonial material is available for download. And the question is, what can tribes do about it? Certainly tribes are not, the Hopi tribe is not the only tribe that's faced this. There are hundreds of thousands of these recordings out there in the world held by institutions. And the question is, what recourse do tribes have? How do we go about reclaiming the voices of our ancestors? Well, one of the logical places to start is with copyright law. As it turns out, copyright gives authors, or there's a broad category that you could call writers, composers, filmmakers, choreographers, performers, gives these authors a temporary and a limited right to keep others from using their original creative works in these different ways. So if you hold a copyright, you can prevent other people from reproducing a work, making derivative works, distributing a work, publicly performing or displaying it, or digitally streaming it. So let's say you've just written a script for a new Netflix movie that you're going to get out there. No one can copy it without your permission. They can't even download it to their computer without your permission. No one can make a film or an audiobook of it without your permission. No one can sell copies of it or even post it online. No one can produce it or even release it to the public without your permission. That's what the power that copyright gives. Now, it's important to keep in mind also that copyright doesn't cover everything. And in fact, it's a little bit, it's full of holes when it comes to indigenous creativity. Only things that are newly created by you as the author are protectable. Songs, ceremonies, designs, stories, histories passed down from time immemorial, unfortunately can't be protected through this mode. Second, creative works have to be written down, or they have to be recorded by the author with her permission. This means that things that are just transmitted orally usually don't qualify. It also means that improvised creativity that isn't recorded doesn't qualify. Now I've left an asterisk, and I'm going to come back to this in just a moment. Finally, copyright only protects expressions. It doesn't protect ideas or facts or historical details or principles. Let's say you want to record an oral history with a member of your family. Their narrative might be protected by copyright, but the specific historical facts or the names or the timeline, that can be copied and shared by anyone who gets a hold of it. Now, it's important also to point out that a lot of things are eligible for copyright protection. We talked a little bit about the recordings that Laura Bolton made with the tribal members on the Hopi reservation. Well, assuming that those are eligible for copyright, which presumably they are, those would be protectable. So the question is, if you have a copyright, how do you then protect it? Well, if somebody copies your work or uses it in one of those 5 or 6 ways that are here on the right hand of the screen without your permission, then you may be able to sue them to stop them from infringing that copyright. And you might even be able to collect damages, some pretty substantial damages, as you can see here. I'll just mention in passing that there's also something called an anti-bootlegging law. It's part of the Copyright Act, but it might be useful for those trying to protect ceremonial performances, especially ceremonial music performances. It turns out that even if you haven't recorded a musical performance and secured a copyright on it, if someone comes to that performance and records it without your permission, you can actually sue them in the same way that you would sue a copyright infringer. Think about all the tourists that come to tribal lands and record tribal ceremonies without permission. This anti-bootlegging law could potentially be very powerful for people going forward. Now, copyright law, as I mentioned, is a limited kind of protection. And one of the important limits to keep in mind is this notion of fair use. Fair use is there. It basically allows you to use somebody else's work without their permission when the public benefit of that use outweighs the private interests of the copyright holder. And you might say, well, that's kind of a complex balance. You know, how do I know whether the public benefit of something is more important than my interest as a creator? Well, basically, the Copyright Act has a balancing mechanism. There are 4 parts to it. I won't get into the details of how that works, but it's a balancing act, and courts have struggled with trying to come up with the best way to balance these interests, the public interests and the private interests of authors. In some ways, that's a bad thing. That means that people can use Indigenous works without permission if they have a good, publicly beneficial reason for it sometimes. At the same time, it's kind of a good thing for Indigenous artists sometimes. The fair use doctrine enables certain artists, like the ones I'm showing you here. Jeremy Dutcher is a performer, composer up in Canada, who takes old sound recordings made on tribal lands and then reincorporates them into new, really interesting music. Vernon Aki, the artist who I'm depicting here, takes photographs that were made of individuals of the stolen generation in Australia, and then transforms them into these 3D images that are facing towards you. These are examples of artists that are taking previously copyrighted works and then using them in new ways. This has become kind of a major phenomenon as part of the Indigenous Renaissance in the arts right now, is to take these materials that were previously appropriated to them and reappropriate them for purposes of developing Indigenous cultures today. These could very well fall under the doctrine of fair use and enable some tremendous creativity. Okay, so I've loaded you down with a lot of copyright law, but I'm happy to answer questions, more specific questions about how all of this works in the Q&A. But for right now, I'm going to go ahead and pass the baton to talk a little bit to Cora to talk a little bit about trademark law in the fashion industry.
Thank you for that. Yes, that was a really in-depth explanation, and you can see how already just one form of intellectual property law really is relevant to Indian country. Another example that we wanted to highlight that we thought might be really relevant to the students at Washington State University is this idea of Native American fashion and whether or these issues that we come across about inspiration or cultural appropriation. So if you could go to the next slide, please. Here we have a well-known Native artist named Bethany Yellowtail. On the left side, you have her one of her most recent designs made after and inspired by her own upbringing on the Crow Reservation. And in 2014, we had a misappropriation of this piece of art that she created. You'll see in comparison to the dress on the right side, we had a brand called KTC, which was accused of directly copying a dress made by Bethany Yellowtail. And we know that as Indigenous artists and creators become more successful, their following increases and their brands are given more attention. However, this attention isn't always a good thing and can sometimes turn ugly, as in this case. Like I said, in 2014, she created this beautiful dress, and she and the Indigenous community noticed that this dress was being walked in Paris Fashion Week by a non-native brand, which is KTZ, and noticed the form of the dress is the same with the color, the length, and the shape, and the designs are clearly very inspired by Bethany's. But we know from many pieces of Indigenous artwork that designs like this created by Indigenous artists are not just a collection of abstract shapes, but she utilized crow beadwork that had been in her family for generations for her design, and the colors and shapes have meaning and origins and a history to them. So they belong to her, they belong to her family, and they belong to her tribe. They are cultural property and not designs that are freely for the taking. She mentioned in a quote for an article that we referenced that this particular design actually was her great-grandmother's, Irene Yellowtail. And in the early 1900s, the design was actually really traditional to the Crow people. And she was told that, or what really inspired her for this was that the way that these shapes are placed together and designed kind of harken to this balance that is meant between the spirit world and the physical world. And that's where the Crow people live. And so you can see how super important a design like this is, and to have it misappropriated by a company that has no ties to the Indigenous community is examples of how intellectual property law could help. And there was a legal case that went into the details of how we could use intellectual property laws as a tool to help protect our designs. Example 2 on the right is another form of cultural appropriation, but more specifically for the Navajo trademark. In 2016, the Navajo Nation sued the big company known as Urban Outfitters over the Navajo name. And you'll see that you do a quick search and the Navajo name is kind of plastered on all these different products. And in this case, the company argued that the term Navajo is a generic name, or it's a designation in the fashion industry. And because the Navajo Nation has allowed multiple third parties to use that term, they shouldn't be getting sued. And the Navajo Nation, however, argued that the use by Urban Outfitters was unauthorized and was being misappropriated by companies like Urban Outfitters for trendy fashion moments. And I just thought it was interesting that one quote from the case was that Urban Outfitters attorneys argued that just as the term light beer is generic for a type of beer that is light in body and taste or low in alcoholic or caloric content, Navajo today is just as generic of a descriptor for a particular category of design or style. And so you can see how in this new age we have all of these different issues that intersect with Indian law and IP law that really kind of erase the meaning behind these names, the names of my people and my tribe. And so I really love talking about this example because you can see the nuances behind how intellectual property law could be used against us or to protect us. If we could move on to the next slide, please. So going over those examples, we wanted to start with them just to get your head thinking, and whether it's stealing a design or using a tribal name without permission. Issues like these are examples of trademark infringement. And trademark law is a form of intellectual property law, like I've said before, and can be used as a tool to help protect our people. In this case, we want to provide an overview of what a trademark actually is. And it could be a word, a symbol, slogan, a design, or a combination of any of those that identifies a source of a product or a service and distinguishes it from other products or services. And so you can see on the slide that you have the Netflix logo or Coca-Cola logo, or even if you've ever been driving and on the highways and you've seen big semis with the Navajo trademark on these big shipping semis, that's a trademark in itself. And I think Trevor will discuss a little bit more about another example of trademark infringement to tie this section up a little bit more concretely if you go to the next slide.
Sure. So, trademark infringement. So what do you do if somebody takes your tribe's name, or maybe the brand that you've created for a product? What do you do when somebody uses that without your permission? What are the options there? Well, to prove trademark infringement requires basically 3 steps. The first one is you have to show that the other party that's using your trademark didn't get permission to use it. That's pretty straightforward. You know whether or not you've given permission. The second one is you have to prove that the trademark is valid. Now, what does it mean to have a valid trademark? Well, pretty much everything that Cora just explained, that it distinguishes your goods in the marketplace, so that it's an indicator of the source of those goods. That's how you show it. Or even more simply, you can show that you've registered your trademark with the Patent and Trademark Office. And that's one of the most important pieces that the tribes are doing right now, is getting out there, registering their tribal insignia, their flags, their names with the Trademark Office, so that everybody's on board, everybody knows, they have notice that your trademark is a valid one and it's registered. Finally, you have to prove that there's a likelihood of confusion between the trademark and the brand or the name that you're going under. If I were to step back really quick, when you look at the Navajo trucking name, many of us would think, hey, is it the Navajo Nation that's sponsoring this trucking corporation? There could be some confusion. So basically, the courts want us to show them that there are 2 different brands or 2 different marks or names. They're similar, very similar. Both of them are distinctive. And that the goods could be confused, right? There could be some confusion. A lot of times what attorneys will do is go out there and do consumer surveys to find out whether or not people really are confusing the marks. Now, I wanted to show this example off to the left. This is a case that's currently pending in the District of Alaska. It turns out that this beautiful raven's tail coat that you see up on the top, this design, was appropriated. I believe this is a Tlingit coat, an artist that created it. That mark was, it seems, appropriated by Neiman Marcus in a coat that they've designed, or at least they put out there on the market. And so the Sea Alaska Heritage Institute, which holds the intellectual property rights, is actually suing Neiman Marcus to show that there's been an appropriation of that mark, of that brand, of that particular design. And so they're trying to prove up each of these 3 steps. Now, we'll have to wait and see what the court decides, but it's a remarkable way that tribes, tribal members, and organizations representing tribes are trying to hold these fashion designers accountable for taking designs, marks, brands, those types of things, symbols, and using them without permission.
And so we wanted to provide a quick exercise for you all to show you how accessible it is to figure out whether or not somebody may be appropriating a trademark. As you'll see on the screen, we put a screenshot of the U.S. Patent and Trademark Office, which has a database that anyone, anywhere could go and search for a trademark to see whether or not it has already been registered or applied for. Similar, if like, for instance, if you were going to apply for a trademark for your business or any type of design that you might have, you could go on this website and put in a name or description and to see if there are any other existing trademarks out there that are similar to your trademark or used on related products or for related services. However, it's important to note that this database is federally based, and there are other trademark databases like state databases. So your search could literally become 10 times or 50 times bigger. So really, you have to go through and do a thorough search of whether or not there is a trademark out there that's similar to yours when you're considering registering something like this. And I think, for example, that we looked up the Navajo trademark, the Navajo name in this trademark search, and you can see on the screen that there are a number of different descriptors of what this one word is going to pull up, and some of them are familiar, like our Navajo Nation tribal casinos, or the term Navajo, and just a variety of different ways people have gone out and tried to secure and license their Navajo trademark. And so moving on to the next slide, we really wanted to incorporate this piece of intellectual property law in social media because we felt it would be really relevant to this audience. And so over the next couple of slides, we'll talk about what happens when you or I post content to Facebook or Instagram, even YouTube, and my favorite, TikTok. So Dr. Reed will take it from here.
Great, thanks, Cora. So there are a couple of questions that we have to ask. We have all of these intellectual property rights that are out there that protect, different kinds of media. And the question is, how does social media change the landscape? Well, one of the big ways that social media changes things is that every time you join a social media platform, you agree to a contract. And that contract has certain designations. It tells you what will happen with your intellectual property. In fact, you agree to give a lot of permissions out there in the world for people to go ahead and use the material that you post. So let's talk a little bit about what some of these look like. What really are you agreeing to when you sign up to be on Facebook, Instagram, YouTube, and TikTok? So this is the Facebook, Instagram one. I'm not sure how much longer Facebook and Instagram will be owned by the same company. It seems like that might be short-lived based on what happened yesterday. But for right now, they use roughly the same licensing agreement. When you share, post, or upload content that's covered by intellectual property rights, so the license says, you grant to Facebook a non-exclusive, transferable, sub-licensable, royalty-free, and worldwide license to host, use, distribute, modify, run, copy, publicly perform, display, translate, and create derivative works of your content. So what exactly does all that mean? Well, if I could explain a little bit just based on these terms, I won't give you legal advice because that's not my job, but I can at least explain what some of these are supposed to be doing. This grant of rights, whenever you post a picture or an iPhone video, you're basically giving to Facebook the right to not only use it for their own purposes, but also to sub-license it out to other people. And not only just to people in your community or those friends on Facebook, but you're also allowing them to potentially use it in other parts of the world, right? A worldwide license. Now, I look at the green language. Ask yourself, is there any potential use of your intellectual property that isn't covered by these words? These are incredibly broad verbs. Host, use. I mean, pretty much anything you could do with intellectual property is a use, right? Distribution, modification, all of these things are covered. Instagram has very similar terms and conditions. So, I mean, it's a very sweeping grant of rights. Now, keep in mind that what isn't being done here, you aren't actually giving up your copyrights to pictures, iPhone videos, songs, whatever it is that you're posting. You actually aren't giving up your copyright, but you are giving a ton of permission out there to pretty much anybody that's using Facebook, or at least that's within the privacy settings that you've set, to go ahead and use the materials that you're posting on there. So it's pretty expansive. YouTube is even more expansive, right? You're not only granting to YouTube this worldwide license, but you're also granting to each user of YouTube a worldwide non-exclusive royalty-free license to go ahead and use, reproduce, distribute, prepare derivative works, all of those things. The question is, what does that mean for you? Let's say that you have recorded something that you just want to share with a couple of friends on Facebook. Maybe you've recorded like a powwow performance or a dance or something that maybe is needs to stay within your community, but you want to get it out there to your friends, right? Keep in mind that when you're doing that, you're actually giving a lot of permission out there. And that permission that you're granting may conflict with the groups that you're filming or recording. So be careful when you put stuff out there on social media. The minute you agree to these terms and conditions and then you upload the material, all of a sudden you've given this blanket permission. Okay, there are a couple of other things to point out, but I'll just be very quick here. On Facebook, YouTube, Instagram, pretty much any social media site, you agree that you won't post material that actually belongs to other people. That's actually a good thing because when people are like Laura Bolton, if she were around today, perhaps she would post all of our Hopi recordings to YouTube or to Instagram. It's possible. And if she were, then, you know, considering that the performers have the rights to those materials, then we would probably say, we'd probably call up YouTube and say, hey, can you take that down? I don't think Ms. Bolton has the rights to those things. The other piece is that most of these services have non-discrimination policies. So if we see people saying inappropriate things about tribes or tribal members, we may be able to use some of these provisions in these policies and request that those be taken down. All right, how about TikTok? I'll hand the baton over to Cora to explain.
Thank you for that. So for those who aren't familiar with TikTok, TikTok is one of the leading growing platforms for creating and sharing short-term videos. And TikTok's terms of use and community guidelines are really broad. It's similar to YouTube and Facebook and Instagram. For TikTok, if you agree to use the platform, you're not allowed to post or share any content that violates or infringes upon somebody else's rights, similar to YouTube. And so that you kind of have that built-in protection as well. But I think it's super important and something that I wanted to highlight in this presentation because we see that with TikTok, so much of the content is user-based. And so specifically the content that a user would upload would cover, without limitation, any text, photo, user videos, sound recordings, and the musical works embodied therein, including videos that incorporate locally stored sound recordings from your personal music library or different noises. And something that, an example that I wanted to highlight was this young Salish and Cree woman named Tia Wood. She's a content creator on TikTok, and she has over 1.6 million followers and about 290 videos uploaded. And this example showcases her song duetting with another TikTok user. But you'll see on the screen that like the language that's incorporated with other social media platforms, you actually grant a lot of permission to the TikTok platform to use whatever content that you post on this website. And so you still own your copyright in the content that you publish, but like Dr. Reed said, you grant so much permission that it's kind of unknown about how much control you actually have over your own content. And so when we begin to think about the evolution and the creativity of our young Indigenous TikTokers and the songs that we're singing or the dances that we're showing on platforms like this, it could really be catapulted into a different area. And so we just wanted to highlight this example of how you could protect yourself. Maybe you could think twice about what you want to share or publish on social media platforms like this. And next, I think we'll just wrap up with a couple of takeaways that we wanted to offer you all. As you've seen, our presentation transform over the course of this last hour. We started with an example in the 1940s, and now we're talking about TikTok. And so we live in an ever changing world, and protecting our Indigenous cultures and ourselves as Indigenous people is really critical. And this is just a new frontier of where the law could protect us, and in some examples could harm us if we don't know what we're signing up for or how to protect ourselves. I think Professor Reed will talk about some of the work that he's done and the work that we've done together over the course of our time working together in law school.
Yeah, thank you, Cora. And what's important to keep in mind is that this field is evolving, and we really do need more individuals who are interested in learning about the law, whether that means going into legal practice or working for tribes or supporting nonprofits that support tribes. This is an emerging field. It's a time for us to come together and find ways to support tribes in a more positive way. So I invite many of you, if you're interested in law, consider pursuing education in Indigenous IP. We'd love to have more of you around. But so Indigenous IP spans many different things. Currently at ASU, we're developing a tribal IP rights handbook for Indigenous innovators, creators, inventors, entrepreneurs. Basically an online resource where you can, first of all, learn about your rights as an inventor, creator, or entrepreneur, and then find out how you can enforce those rights. You know, do I need to register my trademark? Well, these are the steps that you can follow to do that. How do you register a copyright? How do you know whether somebody's infringing your rights? So we're developing this handbook as we speak. Another project that we're involved in is we're aggregating all of the Indigenous intellectual properties that are currently available in institutions, universities, museums, archives around the country, and providing a searchable database where tribes can look up where all their IPs are at. Sometimes tribes don't even know because all of that information is held closely by institutions. So we're going out there trying to find those and putting them in a place where tribes can search for them. And then finally, we do these types of projects, right? Where we go and we speak to groups of students like you who are interested in learning more about this topic, and help inform people about what rights look like in Indian country. It's a growing field again, and we need to be able to get more people on board, help educate people about what's out there. Not only just the federal rights we've talked about, but also tribal rights. So I hope you've enjoyed the presentation. I see that we have a number of questions in the chat, and we'd love to speak to as many of those as we can get to. And if not, please feel free to reach out to us. Here are our email addresses. If you have a specific question that we don't get to, please feel free to connect with us, or if you're interested in pursuing studies in this area. So I think that's it. I guess I'll pass the baton back to our hosts today to see what they want to do next.
Thank you, Professor Reed and Ms. Cora for your presentation. Now we're going to transition to questions for the rest of our time being here. The first question, it's from Michelle on YouTube. Is there a particular form of Native American culture that is easier to protect? And their examples are music, imagery, designs, etc.
Well, I can take that really briefly. It's the challenge here is that different types of Indigenous intellectual property have their own aspects to them, and even a different tribe's tradition, even if it looks a particular way and it might be similar to another tribe's tradition, might be more difficult to protect depending on who the owner is or when it was created. All of those different aspects. So. It's hard to generalize, but what I can say is that, what tools do we have that are really powerful, that really help out in Indian country? Well, Trademarks have been successfully litigated, or at least defended in Indian country. We've seen kind of more work on that front than probably any other area of intellectual property. I think copyrights are also very powerful. They protect a lot, but again, there are certain limitations, right? They have to be recorded. They have to be original to the author. So musical works, designs, things like that, they may be protected pretty easily with copyright, but if they aren't written down or if they aren't original to the author, it might be harder. So yeah, it's really a case by case, unfortunately. But if you have specific questions, I'm happy to answer those offline if we get to that.
Okay, awesome. Our next question is from Ben Calobretta. The Seattle Seahawks logo comes from a Pacific Northwest tribal design, I believe. Do the tribes have any resources at this point after 45 years?
Well, I can start the conversation on this one too. Let's see. So I don't know if I can comment specifically on the Seahawks design. I actually don't know enough about that to give you a comment on it, but I can at least talk a little bit about what could be protected. As Cora was mentioning, designs can fall into potentially two camps. You can protect designs if they are used in commerce. You can protect them through trademark law. So if a particular tribe has been using a design for generations in commerce, or even just recently in commerce, maybe they put it as a mark on a particular type of item, then as long as it's distinguishable from other marks, as long as it's distinct and it meets all the other requirements for a trademark, then yeah, even after 45 years, it can still be valid and you can defend it. What's remarkable about this is that tribes have been using brands, for lack of a better word, for a very long time, have been putting symbols on things and trading them around for a very long time. And trademark law doesn't have an endpoint. As long as you're still using the mark in commerce and it hasn't become generic, you can continue using that mark and defending it. So yeah, even after 45 years, a traditional design might still be defended. Copyright law also protects designs, but again, it has some limitations. There's the fair use exception that we talked about, which may make it harder to defend. But again, yeah, there are some tools available for marks like that. Cora, did you want to add anything?
I would just add that, yeah, like you mentioned, that we can't talk about specifics, but I think that this question really highlights an area of intellectual property law that we've been struggling with over the past couple of years of our research, of how we see these federal laws don't really connect with the works and pieces of art and designs that are within our Indigenous communities. And it's almost like we're trying to fit all of the things that we want to protect into a system that wasn't meant to protect these type of things. So when we think of original works like oral traditions or oral histories, in some communities, we don't know how that originated, but we continue to pass those stories on. And because I wanted to mention that, but like sometimes this area of law, as it's still developing, especially for Indian country, those are really big questions, and we would love more help in trying to figure out how better we can protect these type of designs and cultural properties.
All right, thank you. We have another question from Jasa Grunlos from Wazoo Native American Programs. She asks, can costume companies get sued for having Native American costumes for portraying like cheap regalia?
So this is one of the challenges, right? And let me just start out by saying, the types of uses of stereotypical Indigenous figures has been deeply offensive to a lot of people. We've seen the Washington football team, right, change their mascot because of public pressure. Unfortunately, prior to that, there was a trademark infringement, or not trademark infringement, but a trademark cancellation suit brought against the Washington football team that ended up losing in the Supreme Court. One of the protections that we all have is the First Amendment, right? That allows us to express ourselves, even expressing, as the court said, the ideas that we hate. So most recently, the Supreme Court has upheld people's rights to express themselves over these types of concerns about racism getting into our systems of commerce. So, can a costume company be sued for having a costume that disparages Indigenous peoples? There really currently isn't a way for people to prevent that from happening. It used to be that currently still the Lanham Act, the Trademark Act, has a provision that says that you can't register a trademark that disparages people. But as I mentioned, the Supreme Court struck that down as in violation of the First Amendment of free speech. So unfortunately, you can now register trademarks that are racist, are sexist, that are derogatory, right? After that decision, we saw numerous people registering the N-word, swastikas, things like Aunt Jemima, right? People trying to get in there and register these marks now that it was available. So unfortunately, trademark law isn't a great avenue. Copyright also doesn't provide, there's no review mechanism in copyright law where the Copyright Office official is weeding out things for stereotypes or for other offensive material. So really what it comes down to is you and I, you all and us, right? Being able to put pressure on these organizations to stop doing that kind of a thing. Our free speech protections are very expansive, and because of that, we have to use public pressure, public opinion pressure. And remarkably, as we saw this summer, it really does work in some circumstances. Cora, is there anything else you want to add?
I think that you covered that really well.
Great.
Okay, awesome. Thank you so much for your answers. So we have time for about one more question. So here, another question from Jasa. Is there anything wrong legally with business using Native American imagery in their logos, such as headdresses?
Well, so this is a challenging question, right? A lot of it has to do with one's perspective. From a point of view of somebody who knows nothing about Indigenous culture, maybe there's nothing wrong with that, right? If you don't have any frame of reference to determine whether or not that's offensive, maybe it doesn't affect you. But we do know that from other positions, from other vantage points, doing something like that could be really, really offensive. We saw examples of this. Pharrell Williams, right, donning a headdress on the cover of Elle magazine, and received a lot of flack for that. Well, that's because in some Indigenous communities, the headdress can only be worn by certain people, right? It has deep symbolic and also authoritative power within a community. And for somebody to wear it without having gone through the process of being able to exercise that kind of authority is deeply offensive. So, it's not just, is there anything legally wrong? Well, at the tribal level, there may be actual tribal laws that say, no, you cannot wear this kind of headdress, or protocols that say, no, you can't wear this. And so within the reservation or on tribal lands, that might be against the law, and you could have some sort of action brought against you. Now, what about off the reservation, off of tribal lands? Well, it's a little harder, right? Tribes don't have the jurisdiction. They can't go out beyond their borders and try to enforce their laws very easily. It's quite challenging to do that. So, it really does depend on who you are and where you're located, whether or not that would be a legal wrong. In addition to being a moral wrong, that also depends on your subject position, where you're coming from. Cora, do you have any opinions on that?
I think you really hit the nail, or hit it on top of the nail with your explanation. But I would say in the area of like trademark law, it's really hard to, I think about those issues and see that imagery But I think, again, you have to look back at the specific language of what a trademark is or what a copyright is and how it intersects with commerce. And, I think if there was an example of, like we saw with the Bethany Yellowtail example, complete copy or inspiration of a design of like a headdress out in commerce, that could be an avenue for tribes to have that. But I think that's a conversation that we've had before of, how can tribes protect ourselves? Do we have to, within the area of federal intellectual property law, do we have to be the ones that create these designs and logos in order to prevent other people from creating them and using them, so they don't disparage our names or these symbols? And I think, again, that kind of harkens to how a lot of the area of Indian intellectual property law in Indian country kind of works backwards. And so I think there really is a big opportunity for tribal nations to utilize our tribal court systems and laws to create stronger protections for these cultural properties that are super important to us. And that's what I would add to the explanation.
Yeah, absolutely. If there's like a headdress or something like that that has a design, then you might be able to protect it, as Cora was saying. If it doesn't have a design, if it's just kind of a generic headdress, that might be more difficult. But again, like Cora was saying, there's a real need for us to work in this space and develop these things and develop the law in this area.
Thank you for your answers. We actually have one more question that we can ask. We have like 5 more minutes. They said, I wonder if our speakers see things changing with regard to reparation and general views of cultural appropriation. Do you guys think that it's getting better or worse?
Trevor, do you want to take this first, or shall I?
You can go ahead. Yeah, go ahead.
Okay. I think as I've come into the legal field and seeing how technology has been developing, we're becoming a lot closer. And I think with more people out there on social media, again, it's like a double-edged sword. Like, you see so much on social media that might be harmful to communities, but I think we also that's an area of activism that we as individuals could put public pressure on these big companies or corporations like the Washington football team to get things changed. So I do think with all of the technology that we have now and having conversations like this, I think the conversation definitely has shifted, and there is hope for a more positive and more culturally appropriate area in this space of the law. Do you have any thoughts, Trevor?
Yeah, I think there's reason to be very hopeful about the future. I've had conversations with leaders in the Copyright Office, with the Trademark Office, and just seeing people's interest. They're seeing creativity and innovation happening on tribal lands, and they want to be able to create ways to protect these things in a way that reflects tribes' needs. It's a challenge because a lot of these intellectual property systems were not developed with tribes in mind. They aren't nuanced. They don't want to safeguard the same things that tribes want to safeguard a lot of the times. And other times they do. They're very helpful. And so I think we're getting to a point where I think we'll start to see more and more legislation pass through Congress. We'll start to see more litigation happening with the decision in McGirt versus Oklahoma. That was the decision where the Supreme Court this last summer recognized that the boundaries of the Muskogee Creek Nation were never diminished or disestablished. So now, the city of Tulsa is part of a reservation. we're going to see people now asking, okay, wait, if I create work in Tulsa, am I subject to tribal intellectual property laws, federal intellectual property laws? All of these questions are going to have to be asked and answered. And so I think we're just at the tip of the iceberg of seeing this area of the law develop and grow. And so I think it's a great time to be in it.
Awesome. Thank you so much, Professor Reed and Ms. Coruscant. You have given us a lot of great answers and a lot of new information. I would also like to thank our audience for coming here, and thank you so much for our co-sponsors, the Native American Programs and the Foley Institute. We all hope that you enjoyed this session and that you learned a lot, and that we hope we see you next year. So thank you so much.